Other constitutional provisions dealing with the jurisdiction of the Supreme Court. Article 9, Section 7, Paragraph A, 1987 Constitution. Each commission shall decide by majority vote, unless otherwise provided by this Constitution or by law. Any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. The COMELEC, COA, and the CSC act also as courts of justice. They have powers to decide certain cases within their jurisdiction. Election cases are covered by the COMELEC, claims against the government by COA, and eligibility or removal from government service of an appointive employee by CSC. Now, according to Section 7, any decision, order, or ruling of these commissions may be brought to the Supreme Court on certiorari, etc. So you will see that the decisions of the constitutional commissions are reviewable by the Supreme Court. However, Congress amended the judiciary law, particularly Section 9, on the jurisdiction of the CA, by now making decisions of the CSC no longer appealable to the Supreme Court directly, but appealable to the CA. So based on the present law, out of the 3 constitutional commissions, the only ones whose decisions are appealable directly to the Supreme Court are those of the COMELEC and the COA. What is the basis for Congress to pass such a law where a decision of a constitutional body, CSC, is reviewable by a non-constitutional body? Under the Constitution, decisions of the constitutional commissions are appealable to the Supreme Court. Does Congress have the power to change that by making it appealable to the CA? Yes, because the provision it says, unless otherwise provided by this Constitution or by law, meaning the decisions are appealable to the Supreme Court unless otherwise provided by law. The Constitution itself gave Congress the power to change it. Supreme Court as Presidential Electoral Tribunal. Article 7, Section 4, last paragraph, 1987 Constitution. The Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election, returns, and qualifications of the President or Vice President, and may promulgate its rules for the purpose. If there's an electoral protest for the President and Vice President, the matter is not to be decided by the COMELEC, but by the Supreme Court, acting as the Presidential Electoral Tribunal. Judicial review of presidential proclamation of martial or suspension of the privilege of the writ of habeas corpus. Article 7, Section 18, Number 3, 1987 Constitution, Commander-in-Chief Clause. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of extension thereof, and must promulgate its decision thereon within 30 days from its filing. So the Supreme Court, in an appropriate proceeding filed by any citizen, reviewed the sufficiency of the factual basis of the proclamation of martial law, meaning the Supreme Court can inquire into the basis on why martial law is declared. This is intended to prevent the Supreme Court from invoking the political question doctrine laid down in many earlier cases, that is the prerogative of the President to determine, at his discretion, the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of extension thereof. Congress and jurisdiction of the Supreme Court. Article 8, Section 2, 1987. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. Congress may change or even remove the jurisdiction of the RTC or CA. The law can change them because jurisdiction over the subject matter is conferred by law. However, Congress does not have the power to lessen or deprive the Supreme Court of its jurisdiction under Section 5, Article 8. However, Article 6, Section 30 states, "No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence." Thus, Congress cannot lessen, but it can increase the Supreme Court's powers and jurisdiction, provided it is with the latter's advice and concurrence. So, more or less, these are the scattered provisions of the Constitution dealing with the Supreme Court's jurisdiction. The Supreme Court is not a trier of facts. There are important principles worthy of note in relation to the jurisdiction of the Supreme Court. The Supreme Court is not a trier of facts, which means that passing upon a factual issue is not within the province of the court. Romis Freight Service versus Castro. The finding of facts of the Court of Appeals are not generally reviewable by the Supreme Court. Sarmiento versus U. Also, factual findings of the trial court, particularly when affirmed by the Court of Appeals, are generally binding on the court. Tan versus GVT Engineering Services. It is not the function of the Supreme Court to determine the weight of the evidence supporting the assailed decision. Junior Blanco versus Quasha. However, factual issues may be delved into and resolved where the findings and conclusions of the trial court or the quasi-judicial bodies are frontally inconsistent with the findings of the CA. Office of the Ombudsman versus Tongson. Exceptions. While it is a settled rule that the Supreme Court in the exercise of its power of review is not a trier of facts, jurisprudence has however recognized several exceptions in which factual issues may be resolved by the Supreme Court, namely, 1. When the findings are grounded entirely in speculation, surmises, or conjectures. 2. When the inference made is manifestly mistaken, absurd, or impossible. 3. When there is grave abuse of discretion. 4. When the judgment is based on a misapprehension of facts. 5. When the findings of facts are conflicting. 6. When in making its findings, the CA went beyond the issues of the case, or its findings are contrary to the admissions of both appellant and appellee. Next, when the findings are contrary to the trial court. Next, when the findings are conclusions without citation of specific evidence on which they are based. Another, when the facts set forth in the petition as well as the petitioner's main and reply briefs are not disputed by the respondent. And next, when the findings of fact are premised on the supposed absence of evidence and contradicted by the evidence on record. And finally, when the CA manifestly overlooked certain relevant facts not disputed by the parties, which, if properly considered, could justify a different conclusion. Cristobal Cruz versus Cristobal. Ears of Tickman versus Carino. Safeguard Security Agency versus Tanco. NPC versus De La Cruz. Jurisdiction of the Court of Appeals. Brief history of the Court of Appeals. The jurisdiction of the CA is now governed by BP 129 or the Judiciary Reorganization Act of 1980. BP 129 was passed in 1983 by the former Batasang Pambansa, which practically abolished all the regular courts at that time, and also the special courts except the Supreme Court, which cannot be abolished by Congress. What was also spared was the Court of Tax Appeals, which was likewise not affected. In lieu of these, other courts were created. The constitutionality of BP 129 was challenged as violative of the security of tenure of the judges, but its constitutionality was sustained in the case of De La Lana versus Alba. The CA is composed of over 69 justices after new divisions were created, one based in Cebu City and the other in Cagayan de Oro City pursuant to RA 8246. They decide cases by division of 3. They sit and bank only for administrative matters, not to decide a case, as it would be impractical considering their number. Before BP 129, the court was also called the Court of Appeals. The counterpart of the present CA, though the CA now is different and more powerful than the old one, BP 129 abolished the old CA and created another court which was called the Intermediate Appellate Court, IAC. So from the 1983 to 1986, it was called the IAC. After the EDSA revolution, President Aquino, pursuant to her law-making powers, issued EO number 33, amending the judiciary law, and changed the name of IAC to CA, referring to the jurisdiction of the IAC. Many people thought that the CA of President Aquino under EO 33 is actually the IAC under another name only, but in a case decided by the Supreme Court reported in Letter of Associate Justice Reynato Puno, 210 Square 589, 1992, held. It is the holding of the court that the present Court of Appeals is a new entity, different and distinct from the Court of Appeals or the Intermediate Appellate Court existing prior to Executive Order number 33, for it was created in the wake of the massive reorganization launched by the revolutionary government of Corazon C. Aquino in the aftermath of the People Power, EDSA Revolution in 1986. Section 5 of EA 33 also amended Section 9 of BP 129 to read as follows: The Court of Appeals shall have the power to receive evidence and perform any and all acts necessary to resolve factual issues raised in a. cases falling within its original jurisdiction, such as action for annulment of judgments of regional trial court, as provided in paragraph 2 hereof, and in b. cases falling within its appellate jurisdiction, wherein a motion for new trial based only on the ground of newly discovered evidence is granted by it. So, Section 9 of BP 129, which defines the second highest court of the land, has been amended by EO number 33. In February 1995, it was amended again by RA 7902, known as the Act Expanding the Jurisdiction of the CA. RA 7902 restored the power of the CA to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues raised in cases falling within the original and appellate jurisdiction, including the power to grant new trials or further proceedings without limiting the motion for new trial based on newly discovered evidence. Trials or hearings in the CA must be continuous and completed within 3 months, unless extended by the Chief Justice. The essential features of the CA's jurisdiction are as follows: original jurisdiction of the Court of Appeals, original concurrent. Section 9, Paragraph 1, BP 129. Jurisdiction. The Court of Appeals shall exercise 1. Original jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and auxiliary writs of processes, whether or not in aid of its appellate jurisdiction. Note: refer to the discussion, the original concurrent jurisdiction of the Supreme Court with the CA and RTC, etc. The cases where its original jurisdiction is concurrent with the Supreme Court are petition for the issuance of writs of certiorari, prohibition, mandamus against the following: the CSC RA 7902, Central Board of Assessment Appeals, PD 464, NLRC, St. Martin Funeral Homes, NLRC, or the Secretary of Labor under the Labor Code, quasi-judicial agencies, BP 129, RA 7902, Heirs of Hinog versus Melicor, also issuance of writ of certiorari, prohibition, and mandamus against the RTC. Concurrent with the Supreme Court and RTC are those involving habeas corpus, quo warranto, and writs of certiorari, prohibition, and mandamus against inferior courts and bodies. Section 9, number 1, Section 21, number 2, BP 129. Article 8, Section 5, 1987 Constitution. For example, a petition for mandamus against the MTC of Cebu City can be filed with the Supreme Court, CA or RTC, although the policy of the Supreme Court is that it should be filed with the RTC based on the hierarchy of the courts. Vergara versus Suelto. Being concurrent, what will happen if such a case is filed simultaneously in the CA and Supreme Court? The consequence is found in Section 17 of the Interim Rules. In other words, the Interim Rules are still intact. Interim Rules, Section 17, Petitions for writs of certiorari. No petition for certiorari, mandamus, prohibition, habeas corpus, or quo warranto may be filed in the IAC if another similar petition has been filed or is still pending in the Supreme Court. Nor may such petition be filed in the Supreme Court if a similar petition has been filed or is still pending in the IAC, unless it is to review the action taken by the IAC on the petition filed with it. A violation of this rule shall constitute contempt of court and shall be a cause for the summary dismissal of both petitions without prejudice to the taking of appropriate action against the counsel or party concerned. Original exclusive, Section 9, Paragraph 2 of BP 129. Exclusive jurisdiction over actions for annulment of judgment of regional trial court. Actions for annulment of judgment of RTCs, is this similar to an appeal? Is this the same as appealing the decision of the RTC to the CA? No, because in appeal, you are invoking the appellate jurisdiction of the CA. Here in paragraph 2, it is not appellate, but original jurisdiction, meaning you are filing an action before the CA for the first time. And the nature of the action is to annul a judgment of the RTC. The implementation is found in Rule 47 of the Rules. Appellate jurisdiction of the Court of Appeals. Paragraph 3, Section 9 of BP 129 defines the appellate jurisdiction of the CA. Section 9, Paragraph 3, BP 129 says, exclusive appellate jurisdiction over all final judgments, decisions, resolutions, orders, or awards of the RTCs and quasi-judicial agencies, instrumentalities, boards, or commissions, including the Securities and Exchange Commission, the Social Security Commission, the Employees' Compensation Commission, and the Civil Service Commission, except those falling within the appellate jurisdiction of the Supreme Court in accordance with the Constitution, the Labor Code of the Philippines under PD 442 as amended, the provisions of this Act, and of subparagraph 1 of the third paragraph and subparagraph 4 of the fourth paragraph of Section 17 of the Judiciary Act of 1948. Take note, the appellate jurisdiction of the CA is exclusive. Now, if you will analyze paragraph 3, you will notice that the CA is a powerful court because it has exclusive appellate jurisdiction over all final judgments, decisions, resolutions, orders, or awards of RTCs. So as a general rule, if the RTC anywhere in the country renders a decision and you want to appeal, whether civil or criminal, chances are it will go to the CA. It is a powerful court because it covers all RTCs and the appellate jurisdiction is exclusive. And not only RTCs, the law says, and quasi-judicial agencies, instrumentalities, boards or commissions, not only decisions of the RTC, but also of quasi-judicial agencies or bodies, also called administrative bodies. Administrative bodies are actually part of the executive branch but they act just like courts of justice. They can decide cases, and there are hundreds of administrative agencies in the Philippines. And therefore, if you lose a case before any one of these bodies or tribunals, you appeal the decision not with the Supreme Court, but to the CA. The amendments of RA 7902 is even more specific by adding this phrase, including the SEC, SSS, the Employees Compensation Commission, and the Civil Service Commission. That is the addition. CSC, before this law was passed, under the Constitution, decisions of the CSC are appealed to the Supreme Court together with the COMELEC and the COA. But with the passage of RA 7902, the appeal from the SCA has been transferred to the CA. So what is left behind in the Constitution are the COMELEC and the COA. Obviously, the purpose of this statute is to unburden the Supreme Court with so many cases. The phrase, except those falling within the appellate jurisdiction of the Supreme Court, means all cases should be appealed to the CA except those which belong to the Supreme Court under the Constitution. We know that already. And also except those falling under the Labor Code of the Philippines. A labor code is not supposed to be filed in court, but with the quasi-judicial agency known as the NLRC, and you start in the local level from the late arbiter. Then the decisions of the labor arbiter are appealed to the NLRC, and then from there, where will you go? Is the decision of the NLRC appealable before the CA because it is also a quasi-judicial agency, and under the law, all decisions of quasi-judicial agencies are supposed to be appealed to the CA? No. The decision of the NLRC is an exception, except those under the appellate jurisdiction of the Supreme Court under the Constitution and in accordance with the Labor Code, PD 422. NLRC decisions cannot be appealed to the CA, and the only way to elevate it is to the CA by what we call certiorari, not appeal. This is already modified in the St. Martin Funeral Homes versus NLRC case. Also, decisions of the Secretary of Labor under the Labor Code are not reviewable by CA, but they are reviewable directly by the Supreme Court. And then there is the phrase, the provisions of this Act, and of paragraph 1 of the 3rd paragraph and subparagraph 4 of the 4th paragraph of Section 17 of the Judiciary Act of 1948. So, the new judiciary law still makes some reference to the old law. This shows that the entire 1948 judiciary law has not been totally repealed. Some provisions are still intact because of the reference. Now, what is this subparagraph 1 of the 3rd paragraph? It only applies to criminal cases. Example, a person is sentenced to reclusion perpetua. His co-accused is sentenced to reclusion temporal or prison mayor, and all of them will appeal. All of them should go to the Supreme Court. Otherwise, you will be splitting the appeal into 2 parts, modified in the People v. Mateo case, as discussed in criminal procedure. Subparagraph 4 of the 4th paragraph of Section 17 refers to the appeal from the RTC on pure legal question which should be filed with the Supreme Court. Suppose there are questions of fact, or it is an appeal on questions of fact and questions of law. Under the 1948 judiciary law, you cannot appeal directly to the Supreme Court. You must appeal to the CA. The same thing when the issue is on the constitutionality of a treaty, law, legality of tax, when the jurisdiction of the lower court is in issue, as explained here in this paragraph of the Judiciary Act of 1948, if the appeal is 100% constitutional issue, jurisdictional or legality issue, appeal is the Supreme Court under the Constitution. But if it is mixed with questions of fact, do not go to the Supreme Court. you go first to the CA. This is what the paragraph is all about. Exclusive appellate jurisdiction. Exclusive appellate jurisdiction by way of ordinary appeal from the RTC and the family courts. Section 9, number 3, BP 129. Exclusive appellate jurisdiction by way of petition for review from the RTC rendered by the RTC in the exercise of its appellate jurisdiction. Section 22, BP 129, Rule 43, Rules of Court, Section 9, BP 129. Exclusive appellate jurisdiction by way of petition for review from the decisions, resolutions, or orders or awards of the CSC, Central Board of Assessment Appeals, and other bodies mentioned in Rule 43, Section 9, number 3 of BP 129, and of the Office of the Ombudsman in administrative disciplinary cases, in the Mischio versus Office of the Ombudsman, Gonzalez versus Rosas. Note that under RA 9282, the judgments and final orders of the Court of Tax Appeals are no longer appealable by way of petition for review to the CA. Judgments of the CTA rendered en banc are appealable to the Supreme Court by way of Rule 45, Section 11, RA 9282. Exclusive appellate jurisdiction over decisions of MTCs in cadastral or land registration cases pursuant to its delegated jurisdiction, Section 34, BP 129 as amended by RA 7691. This is because decisions of MTCs in these cases are appealable in the same manner as decisions of RTCs. Section 34, BP 129. Power to try and conduct hearings. Section 9, last paragraph, BP 129. The Court of Appeals shall have the power to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues raised in cases falling within its original and appellate jurisdiction, including the power to grant and conduct new trials or further proceedings. Trials or hearings in the CA must be continuous and must be completed within 3 months unless extended by the Chief Justice. Even if the CA is not a trial court, under the law, it has the power to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues in cases falling within its original and appellate jurisdiction, including the power to grant and conduct new trial or further proceedings. Section 9, number 3, BP 129 as amended by RA 7902. The CA may pass upon factual issues as when a petition for certiorari is filed before it. Alcazaren versus Univet Agricultural Products. This paragraph shows that the present CA is a more powerful court than before. It is a unique court. Aside from being an appellate court, it also acts as a trial court. It may receive evidence, but only those evidence which were overlooked by the trial court. It can order a new trial or conduct a new trial itself. The CA may pass upon factual issues as when a petition for certiorari is filed before it. Alcazaren versus Univet Agricultural Products, or in petitions for writ of amparo or habeas corpus data, or in case of actions to annul judgment of the RTC over which the CA has original jurisdiction. If an issue of fact is tried before the RTC, can I always ask the CA to allow me to present evidence? Does it mean to say now that since the CA is a very powerful court, it can take the place of the RTC? That is already interpreted in the case of Linger and Fisher versus Intermediate Appellate Court. Held, the power of the CA to receive evidence refers only to incidental facts, which were not 100% touched upon, or matters which were simply overlooked by the trial court. You cannot opt not to present evidence before the RTC. It only refers to incidental facts. Evidence necessary in regards to factual issues raised in cases falling within the appellate court's original and appellate jurisdiction contemplates incidental facts which were not touched upon or fully heard by the trial or respondent court. The law could not have intended that the appellate court would hold an original and full trial of a main factual issue in a case which properly pertains to trial court. Jurisdiction over the regional trial courts. How many RTCs are there in the Philippines? BP 129, Section 13, Number 1, Creation of Regional Trial Courts. There are hereby created 13 regional trial courts, one for each of the following regions. So the judiciary law has divided the country into 13 areas called judicial regions. From the 1st to the 12th, the 13th is actually in the National Capital Region, NCR, Metro Manila. Every division is divided into branches. Every RTC judge is appointed to a region, which shall be his permanent station, and his appointment states the branch of the court and seat to which he shall be originally assigned. However, the Supreme Court may assign temporarily an RTC judge to another region as public interest may require, provided that such temporary assignment shall not last longer than 6 months, without the consent of the RTC judge concerned. The Supreme Court shall define the territory over which a branch of the RTC shall exercise his authority. The law provides BP 129, Section 18, authority to define territorial pertinent to each branch. The Supreme Court shall define the territory over which a branch of the regional trial court shall exercise its authority. The territory thus defined shall be deemed to be the territorial area of the branch concerned for purposes of determining the venue of all suits, proceedings, or actions, whether civil or criminal, as well as determining the metropolitan trial courts, municipal trial courts, and the municipal circuit trial courts over which the said branch may exercise appellate jurisdiction. The power herein granted shall be exercised with a view to making the courts readily accessible to the people of the different parts of the region, and making the attendance of litigants and witness as inexpensive as possible. Though RTC Cebu City is found on the 7th Judicial Region, which includes Cebu, Bohol, Negros Oriental, and Siquijor Province, its territorial area is not the entire region, 7th Judicial Region, where it belongs, or even the entire province of Cebu is limited to Cebu City only because it depends on the territory as defined by the Supreme Court. Now, the law says the Supreme Court has the power to define the area of its branch for purposes of supervising that area and the MTC there. Now, as early as 1983, the Supreme Court has already come out from the administrative order defining the area of responsibility of each branch throughout the Philippines. Interim Rules, Section 2, Territorial Jurisdiction of Courts. A. METTCs, MTCs, and MCTCs shall exercise their jurisdiction in the city, municipality, or circuit for which the judge thereof is appointed or designated. B. A regional trial court shall exercise its jurisdiction within the area defined by the Supreme Court as the territory over which the particular branch concerned shall exercise its authority in accordance with Section 18 of BP 129. Jurisdiction of the RTC, exclusive original jurisdiction. Note: Section 19 was amended by RA 7691 effective April 15, 1994, and entitled An Act Expanding the Jurisdiction of the Metropolitan Trial Courts, Municipal Trial Courts, and Municipal Circuit Trial Courts. Concurrent Original Jurisdiction with Other Courts, Section 21. Appellate Jurisdiction, Section 22. Exclusive Original Jurisdiction of the RTC. Section 19. Jurisdiction in Civil Cases. Regional Trial Court shall exercise exclusive original jurisdiction. 1. In all civil actions in which the subject of the litigation is incapable of pecuniary estimation. What does incapable of pecuniary estimation mean? In an action incapable of pecuniary estimation, the basic issue is one other than the recovery of a sum of money. If ever there is a claim for money, it should only be incidental to the main issue. Where the action is principally the recovery of a sum of money, the action is one capable of pecuniary estimation, and jurisdiction would then depend on the amount of the claim exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs. Raimundo versus CA. The basic issue in an action incapable of pecuniary estimation is one other than the recovery of money. In this case of action, the money claim is merely incidental. How to determine whether the action is capable of or incapable of pecuniary estimation? In determining whether an action is one, the subject matter of which is not capable of pecuniary estimation, this court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether jurisdiction is in the MTC or the CFIs would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, where the money claim is purely incidental to, or a consequence of, the principal relief sought, this court has considered such action as cases where the subject of the litigation may not be estimated in terms of money, and are cognizable exclusively by the CFI. Examples of actions incapable of pecuniary estimation are those for specific performance, support, or foreclosure of mortgage, or annulment of judgment. Also actions questioning the validity of a mortgage, annulling a deed of sale or conveyance, and to recover the price paid, and for rescission, which is a counterpart of a specific performance. Rosell versus Vestille, 304 SCRA 739. Such ruling was, however, modified in Go versus UCPB GR 156182, where the court declared the following as real actions. 1. Judicial foreclosure of real estate mortgage. Actions to annul real estate mortgage. For the reason that a real estate mortgage is a real right as well as a real property. So an action to cancel or annul a real estate mortgage necessarily affects title to the real property. Hence, the real action and jurisdiction is determined by the assessed value of the property. A complaint for expropriation is incapable of pecuniary estimation. Barangay San Roque versus Ears of Pastor. An action seeking to annul a resolution of a government-owned and controlled corporation is an action incapable of pecuniary estimation. Palomoloc Water District versus Palomoloc General Consumers Association. GR 162124. An action to annul a deed of declaration of heirs and for a partition of land with an assessed value of 5,000 is an action incapable of pecuniary estimation where the partition aspect is only incidental to the action for annulment. Russell versus Bastille. An action for partition of a real property located in Taytay, Rizal, and with an assessed value of 20,000, the resolution of which involves the determination of hereditary rights, is an action incapable of pecuniary estimation and thus should be filed in the RTC. Suggested answer from UP Law, Center Bar 2000. Note, this answer could also be subject to an alternative answer when it is argued that an action for partition is one which involves interest in real property. Hence, jurisdiction would be dependent on the assessed value of the property. An action for specific performance to compel the defendant to execute a deed of conveyance covering a parcel of land with an assessed value of 19,000 is an action incapable of pecuniary estimation? Because the main issue is whether or not there is a right to compel specific performance. This answer is also lifted from the UP Law Center, Bar 2000. This answer is subject to an alternative answer which asserts that where the primary purpose of the action is to recover or obtain ownership of the real property, the action is one affecting title to real property and is therefore a real action. In a real action, jurisdiction is determined by the assessed value of the property. An action for specific performance is one generally considered incapable of pecuniary estimation, under the same case Razil versus Bastille. The amount of damages that may be claimed in addition to the prayer for specific performance is not determinative of jurisdiction. Thus, an action for specific performance and damages of 200,000 is cognizable by the RTC, even if the amount of damages sought to be recovered is within the jurisdiction of the MTC. Where, however, the demand is in the alternative, as in an action to compel the defendant to deliver the house for completing its construction or to pay the sum of 644 pesos and 31 cents, the action is one that is capable of pecuniary estimation, Cruz versus Tan. Thus, an action for specific performance or in the alternative for damages in the amount of 180,000 is one capable of pecuniary estimation. Hence, the amount of damages is determinative of jurisdiction. But that is the Bar 1997 question. If, as gleaned by the complaint, the principal relief sought by the complaint is for the court to issue injunction against the adverse party and his representatives to permanently enjoin them from preventing the survey of the subject land, the complaint is not a possessory action, but one for injunction. As such, the subject matter of litigation is incapable of pecuniary estimation and properly cognizable exclusively by the RTC under Section 19, Number 1 of BP 129, as amended by RA 7691, Boquingo versus CA. An action for injunction is within the jurisdiction of the RTC, being an action incapable of pecuniary estimation. An action for replevin of a motorcycle valued at 150,000 is capable of pecuniary estimation. The basis of jurisdiction is the value of the personal property sought to be recovered. The amount of 150 falls within the jurisdiction of the MTC. An action for interpleader is capable of pecuniary estimation. If the subject of interpleader is real property, then the jurisdiction amount is determined by the assessed value of the land. If it be personal property, then the value of the property. Hence, an action for interpleader to determine who between the defendants is entitled to receive the amount of 190,000 from the plaintiff is within the jurisdiction of the MTC. That is Makati Development Corporation versus Tanwatco. The recent decision of the Supreme Court in Bank for Sarmiento Property Holdings versus Philippine Bank of Communication, GR 102836, June 19, 2018, through the ponentia of Associate Justice Marvic Leonen, reaffirms and reestablishes the ruling that the nature of the subject matter of the action, whether it is capable of pecuniary estimation or not, is determined by the nature of the principal action or relief. If the principal relief is for recovery of sum of money or title to or possession of real property, the action is capable of pecuniary estimation. If the principal relief sought is not for recovery of sum of money or real property, even if a claim of sum of money or a real property results as a consequence of a relief, the action is incapable of pecuniary estimation. First Sarmiento Property Holdings versus Philippine Bank of Communication. Special civil action for declaratory relief and quieting of title to remove the cloud over Torrens' title are actions incapable of pecuniary estimation. An action for rescission or specific performance of contracts is an action incapable of pecuniary estimation. But an action for damages for breach of contract is an ordinary action capable of pecuniary estimation. Spouses Pajares versus Remarkable Laundry and Dry Cleaning, February 20, 2017. An action for breach of contract is incapable of pecuniary estimation if the principal relief is for rescission of contract. If the principal relief is to recover damages, the action is capable of pecuniary estimation. The same case, Spouses Pajares. In the recent case of Spouses Pajares versus Remarkable Laundry, a case for breach of contract for rescission of specific performance is incapable of pecuniary estimation, regardless of the amount involved, which is exclusively cognizable by the RTC. If the cause of action for breach of contract is to recover damages, it is an ordinary action capable of pecuniary estimation, and jurisdiction is determined by the amount of damages claimed. The RTC of Cebu was held bereft of jurisdiction because the amount claimed as damages is less than 300,000, which exclusively falls under the jurisdiction of the MTC. RA 7691, Section 5. Special civil action for declaratory relief. Petition for declaratory relief is governed by Section 1, Rule 63 of the Revised Rules of Civil Procedure, which provides as follows. Section 1. Who may file petition? Any person interested under a deed, will, contract, or other written instrument, or whose rights are affected by a statute, executive order, or regulation, ordinance, or any other governmental regulation may, before breach or violation thereof, bring an action in the appropriate regional trial court to determine any question of construction or validity arising and for a declaration of his rights or duties thereunder. Bar Matter Number 803, 17, 1998. An action for the reformation of an instrument to quiet title to real property or remove clouds therefrom, or to consolidate ownership under Article 1607 of the Civil Code may be brought under this rule. As held by the Supreme Court in Velarde versus Social Justice Society, based on the foregoing, an action for declaratory relief should be filed by a person interested under a deed, a will, a contract, or other written instrument and whose rights are affected by a statute, an executive order, or regulation, or an ordinance. The purpose of the remedy is to interpret or to determine the validity of the written instrument and to seek a judicial declaration of the parties' rights or duties thereunder. Gozun versus Lianco. The essential requisites of the action are as follows. There is a justiciable controversy. The controversy is between persons whose interests are adverse. Number 3, the parties seeking the relief has the legal interest in the controversy. And 4, the issue is ripe for judicial determination. Board of Optometry versus Colette. Extrajudicial foreclosure is an action incapable of pecuniary estimation, even if recovery of title, possession, and sum of money are involved. An action to declare null and void an extrajudicial foreclosure proceedings involves issue of ownership or title, possession or recovery of a sum of money. Generally, it is classified as a real action. However, if the issue of ownership, possession, or title, or recovery of a sum of money is only a consequence of the principal action and relief incapable of pecuniary estimation, the annulment of extrajudicial foreclosure proceedings is part of the action incapable of pecuniary estimation and may not be separately classified as capable of pecuniary estimation, since it results only from the principal relief to declare the real estate mortgage involved in the foreclosure proceedings null and void. In the recent case of First Sarmiento Property Holding versus Philippine Bank of Communication, the Supreme Court held that an action to declare the real estate mortgage null and void and to declare the extrajudicial foreclosure proceedings null and void is an action incapable of pecuniary estimation because the nullification of the extrajudicial foreclosure proceeding is only a consequence from the relief in the principal action. An action to rescind or set aside the real estate mortgage is a principal action incapable of pecuniary estimation. Nullification of the foreclosure sale is only a consequence of the principal action, and relief to nullify the real estate mortgage, which is the basis for the extrajudicial foreclosure proceedings. It is logical that if the real estate mortgage is null and void, the extrajudicial proceedings are equally null and void. The spring cannot rise higher than the source. In First Sarmiento, same case, versus Philippine Bank of Communication, First Sarmiento Property Holdings obtained a loan from Philippine Bank of Communication, PBCom, for 40 million pesos secured by real estate mortgage over 1,076 parcels of land on June 19, 2002. The loan agreement was amended on March 15, 2003, increasing the loan amount to 51 million, and further amended on September 15, 2003, increasing the loan to 100 million. On January 2, 2006, PBCom filed an extrajudicial foreclosure of real estate mortgage for failure of First Sarmiento to pay the principal amount and accrued interest. On December 11, 2011, First Sarmiento attempted to file a complaint for annulment of real estate mortgage with the RTC, but the clerk of court refused to accept the complaint. In the absence of the tax declarations of the mortgage properties on which to base the amount of docket fees for real action, the executive judge of the RTC Court of Malolos, Bulacan, granted First Sarmiento's urgent motion to consider the value of the subject matter of complaint as not capable of pecuniary estimation, and ruled that the First Sarmiento's action for annulment of real estate mortgage was incapable of pecuniary estimation. On December 2, 2011, the mortgage properties were auctioned and sold to PBCom as the highest bidder. First Sarmiento filed on January 2, 2012, a complaint for annulment of mortgage with prayer for issuance of temporary restraining order and preliminary injunction to enjoin the foreclosure and registration of certificate of sale in favor of PBCom. That same day, the court issued an ex parte restraining order for 72 hours, and on January 4, 2012, the court issued a status quo ante order. On January 24, 2012, the sheriff issued a certificate of sale in favor of PBCom. PBCom argued that the action for annulment of real estate mortgage was the real action and filing fee should be based on the fair market value of the mortgage properties. On April 3, 2012, the regional trial court dismissed the complaint for lack of jurisdiction for failure to pay the docket fee for real action, ruling that the action for annulment or rescission of contract has the nature and objective to recover real property as follows. Following the High Court's ruling in case of Home Guarantee Corporation versus R. the Second, Builders, and National Housing Authority GR 192549, March 9, 2011, cited by the bank in its rejoinder, which appears to be the latest jurisprudence on the matters, to the effect that an action annulment or rescission of contract does not operate to efface the true objective and nature of the action, which is to recover real property. This court hereby resolves to dismiss the instant case for lack of jurisdiction, plaintiff having failed to pay the appropriate filing fees. Accordingly, the instant case is hereby dismissed. First Sarmiento elevated the case directly to the Supreme Court on pure questions of law, whether an action for annulment of real estate mortgage is an action incapable of pecuniary estimation or real action to recover real property. The Supreme Court granted the petition of First Sarmiento, reversed the stray decision in Home Guarantee Corporation versus R. Second Builders, Inc. and National Housing Authority GR 192549, and reaffirm and reestablishes that the principal nature and relief determines the nature of the action. If the principal nature and relief is not for sum of money or recovery of real property, such as rescission and nullification of specific performance of a contract, the action is incapable of pecuniary estimation, even if the action results in the recovery of real property or sum of money as a consequence. If the principal action is to recover the title to or possession of real property, which is a real action or recovery of sum of money or an action for damages, the action is capable of pecuniary estimation. The Ponencia of Justice Leonin reviewed the cases on action incapable of pecuniary estimation as follows. Section 19, number 1 of BP 129 as amended, provides regional trial courts with exclusive original jurisdiction over all civil actions in which the subject of the litigation is incapable of pecuniary estimation. Lapitan versus Scandia, Ponentes J. Reyes, instructed to determine whether the subject matter of an action is incapable of pecuniary estimation, the nature of the principal action or remedy sought must first be established. This finds support in this court's repeated pronouncement that jurisdiction over the subject matter is determined by examining the material allegations of the complaint and the relief sought. It is axiomatic that the jurisdiction of a tribunal, including a quasi-judicial officer or government agency over the nature and subject matter of a petition or complaint, is determined by the material allegations therein and the character of the relief prayed for, irrespective of whether the petitioner or complainant is entitled to any or all such reliefs. However, Lapitan stressed that where the money claim is only a consequence of the remedy sought, the action is said to be one incapable of pecuniary estimation. A review of the jurisprudence of this court indicates that in determining whether an action is one the subject matter of which is not capable of pecuniary estimation, this court has adopted the criterion of first ascertaining the nature of the principal action or remedy sought. If it is primarily for the recovery of a sum of money, the claim is considered capable of pecuniary estimation, and whether jurisdiction is in the municipal courts or in the courts of first instance would depend on the amount of the claim. However, where the basic issue is something other than the right to recover a sum of money, or where the money claim is purely incidental to or as a consequence of the principal relief sought, like in suits to have the defendant perform his part of the contract specific performance, and in actions for support or for annulment of a judgment or to foreclose a mortgage, this court has considered such actions as cases where the subject of the litigation may not be estimated in terms of money and are cognizable exclusively by courts of first instance. The rationale of the rule is plainly that the second-class cases, besides the determination of damages, demand an inquiry into other factors which the law has deemed to be more within the competence of courts of first instance, which were the lowest courts of record at the time the first organic laws of the judiciary were enacted allocating jurisdiction. RA 7691 Section 5, after 5 years from the effectivity of this act, the jurisdictional amounts mentioned in Section 19 number 3, 4, and 8, and Section 33 number 1 of the BP 129 as amended by this act, shall be adjusted to 200,000 pesos. 5 years thereafter, such jurisdictional amount shall be adjusted further to 300,000 pesos, provided, however, that in the case of Metro Manila, the above-mentioned jurisdictional amounts shall be adjusted after 5 years from the effectivity of this act to 400,000 pesos. Number 4. In all matters of probate, both testate and intestate, where the gross value of the estate exceeds 100,000 pesos, now 300,000, or in probate matters in Metro Manila, where such gross value exceeds 200,000 pesos, now 400,000. In the subject of wills and succession, when a person dies, his estate, his property, will be settled for the benefit of his creditors and heirs. That is what you call either as the state or intestate proceedings, depending on whether the deceased left a will or none. If there are debts to the decedent, thus payable by his or her estate, settlement would mean liquidation, which includes inventory of all the assets and obligations payable, payments of the debts, then distribution of the residue to the heirs. This is done by the court to an administrator appointed by it or through the executor appointed by the decedent. Where should the estate of the deceased person be settled, RTC or MTC? It depends on how much is the gross value of his estate. If it exceeds 300,000, RTC. If it is 300,000 or less, it should be with the MTC. In Metro Manila, again, the gross should be more than 400,000. The jurisdiction of the court as a probate or intestate court relates only to matters having to do with the settlement of the estate and probate of the will of the decedent, but does not extend to the determination of questions of ownership that arise during the proceeding. Number 5, in all actions involving the contract of marriage and marital status or relations. Most of these cases are under the Family Code and now fall under the jurisdiction of family courts, RA 8369, the Family Courts Act of 1997. But because family courts have not yet been constituted, the Supreme Court has designated RTCs to take cognizance of such cases. What are the possible actions which you can imagine involving the contract of marriage and marital relations? Well, annulment of marriage, legal separation, declaration of nullity, dissolution of the absolute community of husband and wife, and action for support. RA 8369, Section 5, Jurisdiction of Family Courts. The family court shall have exclusive original jurisdiction to hear and decide the following cases. D. Complaints for annulment of marriage, declaration of nullity of marriage, and those relating to marital status and property relations of husband and wife, or those living together under different status and agreements, and petitions for dissolution of conjugal partnership of gains. Number 6 will be discussed later. 7. In all civil actions and special proceedings falling within the exclusive original jurisdiction of a juvenile and domestic relations court and of the Court of Agrarian Relations as now provided by law. Before BP 129 or before 1980, there were special courts existing. Among these courts were the so-called Juvenile and Domestic Relations Court, JDRC. Then you have the Court of Agrarian Relations, CAR, which tried cases involving tenancy, agricultural lessor, agricultural lessee, agricultural lands. When BP 129 was enacted, the CAR and the JDRCs were abolished together with the other courts created by law. Cases which they used to handle were automatically transferred to the RTC. That was after BP 129 took effect. What were the cases which were usually falling within the original jurisdiction of the former JDRC? Usually those involving family and children, like support filed by the child against his father, compulsory recognition, custody of children, adoption proceedings. Under BP 129, all of these are now within the jurisdiction of RTC. However, this has been amended again by RA 8369, Family Courts Act of 1997, and these cases are now under the jurisdiction of the family courts. See Sections 5, letter B, C, E, and G.